session. We're in closed session for the first part.
Going into
So members, I declare the meeting open to the public. I advise the committee meeting will be recorded and broadcast throughout Parliament buildings and online. Members, you are very welcome to use your mobile devices as long as they are in airplane mode and all devices are muted. It is not permitted to take photographs or recordings of the meeting. Members, we're moving to agenda item number 7, which is committee membership. I'll ask members to note the committee membership that is listed at page 37 of the meeting folder. There may be changes to that and we will update that, of course, in due course. Agenda item 8, committee procedures. Members, the following guidance papers, which are based on established Assembly procedure and practice, are in the meeting pack. The Guide to Powers and Operation of Standing and Ad Hoc Committees for Chairpersons and Members at pages 39 to 63. A Guide to the Role of Committee Chairpersons at pages 64 to 74. And a Guide for Members to the Role and Functions of the Committee Secretariat at pages 75 to 78. Members, I'll draw your attention in particular to the guidance on privilege and matters of sub judice. I advise members that under Section 50 of the Northern Ireland Act 1998, for the purposes of the law of defamation, absolute privilege applies equally to the making of a statement in the proceedings of the Assembly and the publication of a statement under the Assembly's authority. This privilege also extends to the meetings of the committee. Members should note, however, that privilege does not extend to press conferences or statements made to the press. Committee members should be aware of the potential problems associated with discussing a matter that is sub judice. Sorry, I always pronounce that sub judice. That is a matter which is being or is about to be considered by a court. The sub judice rule is contained in Standing Order 73. It provides that any matters in respect of which legal proceedings are active should not be referred to in committee proceedings except to the extent permitted by the committee chairperson. In such cases, the matter awaiting adjudication should not be prejudiced by comment in a public session of a committee meeting. The rules relating to sub judice are summarised in the Guide to the Powers and Operation of Standing and Ad Hoc Committees for Chairperson and Members at pages 57 and 58 of the meeting pack. And I ask members to note the guidance. If you require any further information or clarification, please do contact our clerks. Agenda item 9 is our declaration of members' interests. Members, a memo from the clerks on declarations of interests in committees is at pages 80 and 81 of the meeting pack. Members, all Assembly members are required to register relevant financial and other interests in the Register of Members' Interests. Details of registered interests are published on the Assembly website. Members, in addition to this requirement, Standing Order 69.5 states that a member who has A financial interest in any matter or B a relevant interest in any matter must declare that interest before taking part in any proceedings of the Assembly relating to that matter. In particular, there's a requirement to declare any interests which might reasonably be thought by others to influence the member's approach to the matter under consideration. Members, proceedings of the Assembly includes meetings of this committee. Members, this is the first meeting of this committee. Members should ensure that any financial or other interests which relate to the remit of the committee or which are likely to be relevant to a substantial part of its work are drawn to the attention of the committee. It should be noted that failure to register and or declare an interest may be an offence under the Section 73 of the Northern Ireland Act 1998. Therefore, I ask, does any member have any interests to declare? Mr. Donnelly.
Chair. Yes, Chair. As detailed in the Register of Members' Interests, I'm also employed as a Band 5, Band 6 registered nurse at the South and Eastern Health Trust, on the nursing bank of the South and Eastern Health Trust. I don't know how relevant that's going to be to the committee, but just to make you aware of it, I have written to the NMC just to seek clarification on that.
Okay.
And again, I've already registered interest in other committees, but again, just for the sake of it, and I don't know whether or not it conflicts in any way at all with this particular committee, I'm a chairman of Niscol na Jerica, the preschool through the medium of Irish, member of the GAA, and a member of Conradh na Gaeilge.
Thank you.
And I would just to refer to what's already registered against me, so where members can see it.
I think, to be honest, for this one, members, given the committee that it is, if anybody has a private member's bill or anything that would be coming forward, it might be at that point that you would mention, because we may well be talking about that as part of our work programme. Thank you very much, members. Just to remind you that the rules governing the registration and declarations of interests are contained in the Code of Conduct and Guide to the Rules relating to the conduct of members, and that further advice and guidance is available from the Clerk of Standards in room 254 of Parliament Buildings. Excuse me. Agenda item 10 then, role and remit of the Committee on Procedures. Members, the Clerk Assistant, Mr Paul Gill, is here at the meeting today to discuss the role and remit of the Committee and potential issues that the Committee may wish to include in its strategic priorities and work programme. Members, a paper on the role of the Committee and how it undertakes its work is at pages 83 to 85 of the meeting pack, if you want to move to that, please. Paul, I welcome you very much to this committee, and we absolutely delighted that you're here and will keep us right. And I invite you now to ask or to bring forward about the committee and how it undertakes its work, please.
Chair, thank you very much. Deputy Chair, members, so thanks for the opportunity for being able to come and speak to you today about the role and remit of the Committee on Procedures. So I know most of you already, but for the avoidance of doubt, I'm Paul Gill. I'm one of the Clerk Assistants here at the Assembly. My role is to provide procedural advice to the Speaker, but I'm also responsible for the Business Office, for Hansard Interpretation Services, for EU Affairs and for standing committees, of which this is one. And it's a very important standing committee, having as it does the function of considering and reviewing on an ongoing basis the standing orders and procedures of the Assembly. So having clear, logical, efficient, fair and well understood procedures is important for any institution, but it's especially important for a parliament or a legislature. And it's important for a number of reasons. Most importantly, I think we need them to provide structure and order to how we carry out business. So the absence of procedures would make it almost impossible for the Assembly to get its work done efficiently. There needs to be clarity and agreement about how business is undertaken, otherwise things would get unwieldy and chaotic very quickly. There's obviously a limited capacity for the amount of business that the Assembly can do, which is greatly exceeded by the amount of business that members would actually like to do. So we therefore need procedures in place to manage the Assembly's time well and actually enable the Assembly to focus on what its key functions are. And as a reminder, there are essentially three categories of business that you as members need to carry out. You make laws, you scrutinise the executive, and you represent the views of your constituents. And anything else is really incidental to those three key functions. So our procedures need to enable and empower you to be able to carry out those functions well. So the Assembly is the prime source of authority on devolved matters, and its procedures therefore need to facilitate a parliamentary culture that reflects this. They need to promote accountability and ensure that the executive gives the Assembly its place to exercise this role. So as well as efficiency, we also need to ensure that our procedures facilitate fair and democratic decision making. Obviously, there are all sorts of competing interests when it comes to the Assembly carrying out its business. We therefore need agreed procedures that need to accommodate everyone as fairly as possible in a democratic fashion, and whether that's ensuring that privileges and entitlements are shared on a proportional basis, or whether it might be in particular circumstances ensuring greater opportunity for minority voices to be heard. We need to ensure that our procedures accommodate good decision making and representation that is consistent with the particular type of power sharing system that we have here. And obviously another issue with fairness is consistency. Where procedures are clearly defined and routinely followed, we can be sure of consistency, and that means that parties and members are treated equally and therefore fairly. Now, obviously, issues will arise from time to time when someone isn't happy with the procedure that's set out in standing orders, and they may in fact have a very good case for why a different procedure would be a better way of doing something. However, if we were to disregard our procedures in those particular circumstances to accommodate this, then this obviously runs the risk that that member or party would receive more favourable treatment than a party or member who had previously complied with those rules. Now, that's not to say, of course, that our procedures cannot be changed. They can, and I'll come on to talk about how you can do that. The point, though, is just to say that until such time as they are changed, following due process and consideration, proper consideration by the Assembly, compliance with procedures is a safeguard that parties and members will be treated consistently and therefore fairly. I should also say that having agreed procedures which are published and available to the public should increase accountability and transparency, which in turn should build public confidence. So while it may be unrealistic to expect that the public will agree with everything that the Assembly does, we do at least want them to understand and value the role that the Assembly plays, to understand why it does certain things in particular ways, and therefore to feel able to be engaged in its work. And obviously having sound procedures is an important part of this. So standing orders detail the procedures that regulate the way in which the Assembly carries out its business. They are the main but not the only source for Assembly procedure. Sitting above standing orders, there are relevant statutory provisions, mostly contained within the Northern Ireland Act 1998, that set out how the Assembly should carry out its business. In some cases, statutory provisions direct the specific procedure that must be followed. In other cases, they say that standing orders shall or may make provision for procedure in respect of a particular area. I should also just mention briefly that procedures are also developed and managed through Speaker's rulings and through convention and practice. A Speaker's ruling can, where appropriate, elaborate on the provision within standing orders. However, they cannot be inconsistent with them. So very often a Speaker's ruling will be appropriate in circumstances where a question of order arises and where standing orders are silent on exactly how a particular matter should be handled. So they offer a more flexible way of dealing with procedural issues as and when they arise. And just to also mention that Speaker's rulings are collated and published by the Assembly's Business Committee at the end of each session, and the most recent one was just noted by the Business Committee and has been published on Assist and on the members portal in case you want to catch up on that. So I mentioned the Northern Ireland Act 1998. In fact, it is the legislation that provides that the proceedings of the Assembly shall be regulated by standing orders, and those are the procedures which this committee are going to be most focused on. It provides that standing orders should not be made, amended or repealed without cross-community support. So there's only a handful of key decisions which always require cross-community support, and these are designated in advance and were anticipated by the Belfast Good Friday Agreement. So it includes things like the election of a speaker, the agreement of budget allocations, as well as the agreement of standing orders. And I think that's just worth noting then that standing orders, obviously, the threshold for agreeing them is actually higher than the threshold for agreeing legislation. So that, I think, signifies the importance that is attached to making sure that they're got right and that there is broad consensus for any changes that need to be made. And it's a reminder, I suppose, that if this committee does want to change standing orders, it should ensure that it has built up that consensus in advance if it wants to be able to get those changes through plenary. Say as well then, our standing orders are permanent in the sense that they remain in place across mandates until such time as the Assembly agrees with that cross-community support to amend them. However, although they are permanent, there is provision for them to be temporarily suspended. Specifically, our Standing Order 77 says that subject to the requirements of the Northern Ireland Act, a member may move a motion for the suspension of one or more orders in whole or in part. And a motion under this order shall require cross-community support within the meaning of the 1998 Act. And the reason that this provision says subject to the requirements of the Northern Ireland Act is that there are actually some standing orders which can't be suspended. Essentially, the Assembly can't agree to opt out of any of the matters which under the 1998 Act says must be included in standing orders. And you'll note that even for suspension, cross-community support is required. A recent example of this is when the relevant standing orders were suspended to allow the budget bill to go through within 2 days. That couldn't have happened if there hadn't have been cross-community support within the Chamber. So for you, as the Committee on Procedures, it's your role to consider and review on an ongoing basis the standing orders of the Assembly and its procedures. And there are all sorts of different ways in which you do this. And perhaps the most important way is through monitoring legislative change, which requires the Assembly's procedures to be amended. So your excellent team of clerks here will carry out that work for you and will bring to your attention any relevant matters that you need to look at. And I should say that in Stella and in Christine, you get vast experience of the Assembly's procedures here. There's not very much, I think, that's ever gone on within the Assembly that one of the two of them hasn't some sort of experience on, so they will be very good at keeping you right on that. There have been instances, and there will continue to be instances, where the law changes to say that the Assembly standing orders should make some sort of new provision. And in fact, there are actually outstanding examples of that from the last mandate, which I imagine you as a committee are going to want to prioritise. So, for example, there was the Northern Ireland Ministers' Elections and Petition of Concern 2022 Act, which came into effect in the weeks immediately prior to the dissolution of the last Assembly. And it anticipates that new standing orders will be made in certain areas. But of course, there hasn't been the opportunity to do that, obviously, with the Assembly not sitting in the period in between. And that's just one example. There are other instances, though, where different stakeholders will bring to your attention issues where they consider or propose there should be changes to standing orders. And key stakeholders include the Speaker and the Business Committee. So, for example, in the last mandate, the Speaker wrote to this committee setting out his desire to have a short period in plenary where members could make short topical statements on various different issues without the Speaker having to judge them against the strict criteria that are maybe set out in matters of the day or urgent orals. And in response, this committee then developed a position on member statements, got agreement for that, brought it forward to the Assembly, and new standing orders were agreed. And member statements have since then become a very popular item of business, which is usually scheduled on at least a weekly basis. Another example was the temporary provisions that were put in place during the last mandate to deal with the pandemic. And again, that was the Speaker writing to this committee asking it to bring forward those arrangements. And I think there actually is a recommendation in the legacy report of the outgoing committee that you may want to look at those temporary provisions, which of course have expired now. Wouldn't have expired if this committee had met at the start of the current mandate, but that recommendation just from the outgoing committee reflected the fact that they expected those temporary provisions to be in place when you came back, and for you to consider whether there was any merit in extending any of them further, or perhaps putting in place on a permanent basis some of the aspects of them. And I would say that the Speaker and the Business Committee really are the key stakeholders for this committee, and I know there's overlap between membership of this committee and the Business Committee, and I think that's a very helpful thing in terms of coordinating positions on different matters. Obviously, it's the Speaker who has responsibility for overseeing and upholding the various requirements of standing orders, so I think it is really worthwhile this committee having a good relationship with the Speaker, and just seeking to ensure that there is a common understanding of whatever issues it is that you're trying to bring forward that the Speaker then might be involved in. Other key stakeholders include the Executive, whose ministers obviously have to comply with the requirements of standing orders when they're bringing their business to the Assembly, and the Chairperson's Liaison Group, who can offer a view on behalf of all committees about relevant standing orders and how they affect committees. From time to time, specific standing committees, such as Committee on Standards and Privileges or the Audit Committee, or perhaps even the new Windsor Framework Democratic Scrutiny Committee, will carry out procedural work and then will come to this committee asking for you to bring forward standing orders to give effect to whatever policy change it is that they've identified. And that sort of work is, I suppose, more straightforward for you as a committee because those committees will have already done the hard work, if you like, in terms of developing the policy. But there will be other occasions where it will be you as a committee that needs to identify the need for change through your own work. And you're likely to do that through carrying out of inquiries. So, for example, in the last mandate, this committee carried out inquiries on legislative consent motions and on private members' bills. And in fact, in both those cases, the reports of the committee were agreed by the Assembly, and they flagged up potential changes to standing orders, which this committee then might want to address as an issue and take forward in due course. And just to say about carrying out inquiries, it's essentially you're doing policy development work when you're doing that. So there's very many similarities to how others develop policy, to how the work that you would take forward. So it's important to do that methodically, to carry out consultation where appropriate with relevant stakeholders, to look at the approaches that are undertaken at other parliaments, to involve the public where appropriate, and to gather and scrutinise evidence. Really, I suppose, Chair, you want to ensure that you have well thought out proposals that will be supported by the Assembly, and crucially, that won't have any unintended consequences that might in fact undermine what it is that you intend to do. I think past experience has shown that probably the easy part of the work is identifying where improvements could be made. What's more complicated then is developing those improvements in such a way that ensures that you're going to garner widespread support and that won't cause those unintended consequences. And those can come around in different ways, maybe through creating rigid rules where in fact there'll be circumstances where flexibility would be more appropriate. It might be by not anticipating how they would affect someone other than the particular stakeholders that you have been focusing on. Or it might even be in the way that they're drafted, creating loopholes that allows those procedures then to be abused by people in a way that undermines those principles that I talked about at the start: clarity and order and efficiency and consistency and fairness. Where you have agreed changes to standing orders, then the process you'll follow, I think it's set out in the paper that Christine and Stella have prepared for you, so I'll not go through all of that, but just to say again, it is important to note that it's the Assembly that agrees those changes to standing orders on recommendation from this committee, rather than this committee agreeing to change those standing orders themselves. So, Chair, I'll leave it there just to say that this committee has a really important role to carry out. I think there are lots of very interesting areas that you may want to look at. You'll be well supported by your excellent team in carrying out that work. You'll also be well supported by our team of in-house lawyers, and I think the Head of Legal Services is going to come to your next meeting and talk to you about the support that they can offer to you. For my part, as Clerk Assistant, if there's anything that I can do to support you, then I look forward to do that, and I'm looking forward to working with all of you. So I hope that gives you a general sense of the sorts of issues that the committee can look at and may want to look at, and I'm very happy to answer any questions, Chair, that you or other members may have.
I was just going to invite members if they have any questions. That just as my position of chair, I will ask questions. Say Danny's indicated. If anybody else wants to come in or Sinead online, please let us know. Paul, you had mentioned there about any changes to standing orders, of course, has to be taken to the floor of the Assembly and decided on a cross-community vote. At the minute in the Good Friday Agreement, cross-community vote means one thing, but that's only either or of a piece. If this committee decided that it wanted to move to the or part, can it do that, or does that have to come as a something from outside? It's not changing the Act, but it's moving to the other option.
So cross-community support is defined in the Northern Ireland Act, and you're right to say that there are actually two options. It means either the support of a majority of the members voting, a majority of the designated nationalists voting, and a majority of the designated unionists voting. So that's the first one. The second is the support of 60% of members voting, 40% of designated nationalists voting, and 40% of designated unionists voting. Now, actually, when something is subject to cross-community support, it's already the case that either of those two standards apply. So if either one of those was met, then cross-community support would be demonstrated. So when you vote in the Assembly and you go through the lobbies and it's a matter where cross-community support, all that data is input in. We know exactly how many nationalists have voted, how many unionists, how many others, and both those calculations are automatically made. So it is, in fact, the case that if either of those standards were met, then the Speaker would announce that cross-community support had been demonstrated and the matter would be able to go through. There are certain instances where it's only just one of these, where it's just parallel consent. So the election of the Minister of Justice, for example, is one of those. And in those instances, it's only the former of those two that applies. So it's the 50% of members voting, 50% of nationalists and 50% of unionists. And those are actually set out in the Northern Ireland Act, and that is what's called matters such as that are transferred matters. So not only is it not open to this committee to be able to change that through standing orders, it's not actually open to the Assembly to be able to change that through legislation either. If there was to be a change to any of that, Parliament would have to legislate to make those changes, and changes like that, I suppose those fall within the remit of the Assembly and Executive Review Committee, who look at parts 3 and 4 of the Northern Ireland Act and can report on these sorts of changes and make recommendations to the Secretary of State if the Assembly felt that there were parts of the Northern Ireland Act that should be amended.
I think it's just from my point of view as chair of this committee, it'd be interesting when I go in to take forward standing order changes and my vote is counted differently to other people. So and I sat on, in fact, with Militia the last time we sat on AERC, and there was work done certainly on that, although the final report I don't believe has been brought forward to this committee. Yeah, Dana, you had a question?
Well, Chair, yes, it was very similar to what you were going to say, actually, just that obviously changes to standing orders is very important, as are the other things that you mentioned, Paul, but requiring cross-community support does discriminate against members who designate as other. And certainly, I do feel sort of uncomfortable that, or we have less of a say in these very important things, and just wanted to put on record that I think that system is something that we should be looking at going forward any way that we can.
Okay.
Thank you.
It may not be for us here, unfortunately, to do that, but if later when we're sending off our letters asking for information, it might be for others to highlight that to the committee. But it sounds like we need to have the houses of other parliaments to make those changes for us. Anybody else have any questions? No? Oh, okay. Paul, thank you very much for your attendance.
Hang on, just 2 seconds.
Oh, sorry, Sinead coming in.
Sure, yes, and apologies, my connection's very poor, so the only way I can get you to stop sticking is to turn my camera off. Yeah, it was just a question around, obviously in the last mandate we had the option to proxy vote. And I'm just conscious that, we have some members off on maternity and, we may have others in the future. And is that something, or how quick could we maybe put that on the agenda for this committee to look at, so that we can accommodate those colleagues who are actually off maternity leave, sorry.
Do you want me to
Yes,
come
please,
back
Paul.
in on that? Yes, proxy voting was actually something that the previous committee had looked at. Obviously, there was a temporary arrangements for proxy voting during the pandemic, but in addition to that, the previous committee had also been looking at the potential for permanent arrangements for proxy voting, and they were looking at that within the context of accommodating members that perhaps are on long-term sickness absence or parental leave. So they had begun that work. I think there was a sense within the committee that there might be scope for taking that forward by this committee. So they have identified that in their legacy report that I'm sure is going to inform your strategic planning. So I think they've said the committee agreed to recommend that a full review of proxy voting should be undertaken in the next mandate, including potential circumstances in which proxy voting might be appropriate.
Okay, fair enough. Thank you, Paul. Thank you, Chair.
Thank you, Sinead. Sinead, I'm with you on the same page on this one. I think this is one of the quick wins that this committee could possibly take forward because some of the work has already been done. I think there's parts of proxy voting that we could probably bring forward quite quickly, other parts that we may need to have a bit more of an in-depth look at, but certainly we have it across councils and other legislators in the UK and Ireland have it, so it's something I think that we could certainly work on.
Have we got in council? I don't know if we've had proxy voting in councils.
Sorry, no, it's the hybrid working. Sorry, I was thinking about in council. So there are other alternatives. That
Also,
can
on the
be
subject of the coronavirus regulations, I think that's going to fall now this month. Next month?
No, it's not. It's extended to the 24th of March. The Committee for Communities has already heard it'll be extended until the 24th of September, and then the permanent arrangements will be made.
Yes, under different regulations, not
Yes,
the current one.
not the coronavirus one. Yeah, you're absolutely right. No, but Sinead, I think that's a fair point to raise. And just to say to members that the issues highlighted by Paul and by ourselves will be included in a list of potential issues that is being prepared and that the committee will consider when identifying its priority work items. Because this committee is meeting regularly enough, we'll get to that on the 10th of April, and then we can move forward as quickly as possible. Obviously, allowing for chamber time and things like that as quick as we can do. I think there's options there on easy wins that we can get done quickly, maybe medium and longer term things that we will have to look at in more detail. Yeah. Thank you very much, Paul. Very much appreciate it. Members, actually, it ties in quite nicely now that we move to agenda item 11, which is the Committee on Procedures Legacy Report from 2016-17. As Paul has mentioned, there are some items that members may well be of interest in that. The report is at pages 87 to 110 of the meeting pack, and that sets out the legacy report, which sets out the key activities, outputs and achievements. Paragraphs in that 27 to 37 of the report also sets out a range of issues that the previous committee considered that this committee may wish to take forward. So if you wanted to go to pages 87 to 110 of the meeting pack and look therefore at paragraphs 27 to 37, these will all be considered at our strategic planning session, which we know now is scheduled for the 10th of April, when the committee will identify its key priorities and work items. Members, you note, if I could ask you to note the legacy report at this stage, but what I would say is if you can start to think about the items that you may want to bring forward, perhaps even talking to your parties or whoever, but it's now time to have a look and see. At our strategic away day, of course, we're going to look at the ability to do some of those items, but if you could start to have a think about that. I know that I'm quite keen. One of the speakers' rulings has been that a short break can be taken during very long debates. Having been someone who's sat through very long debates, when you're that person or the minister that's sitting in that assembly chamber, it's quite difficult to sit for 10 and 12 hours at a time without a break. So while it's a speaker's ruling, I don't know under health and safety whether that's something we might want to consider as a standing order, or do we want to, as Paul has said, leave that at the flexibility of the speaker and of the minister or the member. It can be quite difficult when you're far away from that speaker's desk and maybe you don't have other members. I know during the coronavirus regulations, when we had much fewer MLAs in the room, it was a very difficult thing. But have a think about it and we'll certainly bring that back together. But the strategic planning session will be the one that we can really get down into how we're going to progress some of these things. So then I'll move on to agenda item 12, which is our committee forward work programme. Members, the outputs from the strategic planning session scheduled to take place on Wednesday the 10th of April as part of the induction programme will form the basis of our forward work programme. The issues to be discussed at that session will be informed by the previous committee's legacy report, and a research paper setting out the procedural issues currently being considered by other legislators will be presented to the committee at our next meeting. So we're just taking a look at what's happening elsewhere to see if there's anything that they maybe are doing that we need to consider. It's also proposed to write to key stakeholders seeking their views and suggestions for possible priority areas of work to inform the committee's discussions. A draft letter and a list of the key stakeholders has been included at the meeting pack at pages 112 to 114. To be honest, I would like to, as chair, propose for your consideration that we also include to that list the Attorney General, and that the First and Deputy First Ministers should be asked to include the views of the Office of Legislative Counsel in their response. It would also be helpful to include Standards and Privileges Committee and the Audit Committee to that list with members' approval, unless members have anyone else that they want added to that list. I will ask then if the members are content to write to the list of key stakeholders set out at paragraph 6, page 113. of your meeting pack, and that the additions you have proposed, or if they wish to make any changes or other additions, will be added then to the list. Yeah. May as well get it all down from them. If you're content with the draft letter at page 114 of the meeting pack, we can go forward with that, or if anyone has any amendments that they would like to make to that. No, then we'll go on ahead. So we'll get that sent out. Members, the initial list of potential issues will be provided in the next meeting pack. The list will be updated when responses are, of course, received from many of those stakeholders that come back to us. If you have any particular issues you wish to include in the list, please contact the clerks to discuss. With the framework that Paul has talked about, you know that they need to be able to enable and empower and promote accountability. So have a think about that when you're bringing anything forward. As you know, we will be asking all your parties as well, so please do start to think about that. They have time now, they'll get their letter and then they can respond by the deadline that's included. Members, so advise members that would you like to include on the list of an addition to standing orders and to provide for a short suspension during, I'm reading over the part that I've just explained to you about. I've said I, for instance, would like that the break would be made to proceedings. As Paul has said, it would need to be clearly defined to ensure consistency, so that would actually help the Speaker. And I think that if we said we must take a break every 2.5 hours, that may not be appropriate, because it might be very close to the end of a debate, so we might need to work in that something with clarity. Just one of those things. It's the sort of wee things that we can look at. I know that the Principal Deputy Speaker had also mentioned about the language that's used in the chamber and how we refer to people and the gender-specific terms that are used that are not included in standing orders. We might get something back on that, for instance. So if members are agreed, then we'll get that letter out. Agreed. Thank you very much. Agenda item 13, correspondence. Thankfully, we have no items of correspondence to consider at this meeting. Agenda item 14 is chairperson's business. In line with what we've heard from Paul, I'll be asking for a meeting with the Speaker, which I am absolutely happy if the Deputy Chairperson, Sinead Ennis, would like to attend that with me. And this is to discuss the potential priority areas of work for the committee. We have had, from the legacy report, some indicators of what the Speaker's office and the Speaker would like us to consider for standing orders. So it's part of that relationship building with the Speaker. If with your agreement, I would like to include in the request in the letter going to the Speaker that was agreed at the previous item, asking him if he could have a meeting just from the Committee of Procedures to discuss that with him, if that's okay. So his letter will be slightly different. So finally we get to any other business. I'm hoping that all our meetings will be this short, folks, but I'm not quite sure. If anybody has any other items of business? No, thank you very much. Agenda item 16 then, date, time and place of next meeting. Members, the next committee meeting will take place here, Wednesday the 13th of March at 10 a.m. So it'll be room 21 Parliament Buildings. And I look forward to seeing you all then. Members, the meeting is now adjourned. We'll just give it a few moments to let the committee close off.
Committee Room 21. Sound.